Big shout out to Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there. How about that?
Of the case of People of the State of Michigan versus Jeffrey Maxon. This file 23-13666FH. Appearances, please.
Before you begin, Dan Burns on behalf of Mr. Maxon.
Thank you. Mr. Maxon is making his way to the defense table. The court also recognizes Mr. Stephen Saladay as an agent from the Michigan Department of Corrections, who has prepared our pre-sentence investigation report. You all may be seated. All right, let me take a quick look to see if I had any corrections noted. Direct the party's attention to page CFJ 284, page 3. 9, I'm sorry, not 3, 9. When we look at entry 10 of 25, I'm looking at the status at the time of the offense. The offense date was June 21st of 1999. However, when I look at the entry 9 of 25, the defendant had an arrest date in the other case of January 14th, 1999, and there wasn't a conviction until October 14th of 1999. Therefore, it makes sense that the status at the time of the offense for number 10 should have been bond. You would have to have been on bond, or otherwise he could not have committed the other offense. Montcalm. Next. Then turn our attention to CFJ 284, page 11. Disregard, I think we're fine there. I meant to say page 13. Now we're looking at entry 20 of 25. I believe that in this Gratiot County case, there was a plea, and that, so we should be able to look at the block that says final charges, conviction method. Mr. Burns, maybe you can tell us, has there been a resolution to that case? And if so, go ahead, sir.
I don't believe he's been sentenced, but
Okay.
My recollection is that he has pled, or he is, we've just founded it over and we have a deal to plea.
Oh, okay. Well, then
it will be use.
But if we don't know, if it hasn't actually entered, it wouldn't be appropriate for me to make that change. We'll go ahead and leave that alone. Now, there's another. It's okay. It's all right.
That is easily enough to establish.
It's okay. Not a big deal. I just thought I'd update it as far as today, which takes me to the next entry on page 14, entry 22 of 25. That is the absconding charge. Has that one been resolved? That's also in Gratiot County.
Hang on just a moment.
It's okay, take your time. As we're doing that, I'm gonna note that for that same one, status at the time of offense says none. It should say on bond.
Yeah, Your Honor, what we have is it looks as though, they will, they'll dismiss the supplemental information. They dismissed count one absconding. And in file 23-162, and he's pleading guilty to use of methamphetamine.
But he hasn't pled yet. If he hasn't pled yet, then obviously I'm not gonna make any changes.
No, this is just the agreement.
Okay, no problem.
This is just the agreement,
No problem. Thank
and we
you.
have a separate.
All right, then I just wanted to update those. I know that there are a series of moving targets. So I just thought we'd take care of that today if we had any additional information. So now I'm going to turn it over to the party. Mr. Wiggins, do you have any amendments, corrections, or objections to make to the contents of the report?
I do, Your Honor. On CHA 284, page 1, under additional information, I think it would be prudent to put in there that the defendant was violated for failing to enroll in testing and failed to enroll in the tether program.
Is that for up here?
Yes.
Yes.
I have a factual issue with this. Your Honor.
Okay.
Oh, pardon me.
No, that's okay. So let's go out. I won't make any amendments until I hear from you. Go ahead, Mr. Wiggins.
Well, Your Honor, on 32124, the court found that the violation existed and remanded him into the custody of jail.
And hold on, let's take a look here at that. I know there was there have been a handful of bond issues. You know, back in January, we had some medical issues that the defendant needed to attend to. Then looks like we were on 3/21/24, and it was found guilty of a bond violation after a hearing. So let's make sure we're talking about the same thing, Mr. Burns, because I know that there were issues where he had medical treatment, things like that.
Actually,
Go ahead.
what I have is, and I believe I put that in, when Mr. Maxson was originally put into, when he was initially incarcerated, he was here. He then bonded out. However, there were holds in numerous counties, as we've just discussed, one of which was Gratiot. He immediately went to Gratiot. When I caught wind that he had bonded out, it was news to me, first of all. I didn't know what he was doing. I don't know what he was thinking at the time, but after speaking with him and figuring out what he had done, I had instructed his sister to cancel the bond. I have texts from her on October 3rd or October 4th. That's back to me like, hey, I just canceled the bond. What should I do? So we canceled this bond back in, and then a month later is when he got, I think is when they violated, like, hey, he didn't like re-sign up. So it's a small window, but it makes a big difference. In addition, all this time, the reason I did it was because I wanted him to get credit for his time. And he would get no credit for that as well. I tried to contact the bond company, it's like Craig's or someplace like that, and helpful. They don't deny it. I mean, I could subpoena the records. I don't know how big it, but it is. I have the text from his sister. It is, I believe, Jermaine. When she looked through her phone, I was trying to get her. She had a difficult time getting her phone records that day on who she spoke with, but I don't know how long they drag their feet, but we canceled. And I don't know if there's an advantage to dragging their feet. I don't even know if they ended up canceling the bond.
That important?
They did March 6th.
Yeah, I was looking for it. I thought I remember seeing it here in a minute. One moment.
If I may, Your Honor, I've already showed this to Corey, but I just, it's on my phone, and I'll show him again, but, her name is Tina Gunnels, and it's Jeff's sister, and she's been my main contact in this. And I have this text from her. And honestly, even the tone of it just appears to me to add to its veracity, but,
All right, I'll just resolve this by saying, I'll take notice that we had some issues here regarding bond, but I won't make any amendment, but I understand the facts.
okay.
Anything else, Mr. Wiggins?
Yes, Your Honor, several things. On CFJ 284, page 6, offense 3 of 25, it's just listed as 2 counts of B&E. I think lien indicates, which would pan out, that was B&E with intent. So I think we should spell that out so that there's no confusion if that was the misdemeanor B&E.
There was no B&E with intent.
According to lien, there was.
Okay.
Back in 1991.
Well,
Oh, yeah, 91. Okay.
to get a disposition of 10 years, it would have to have been a felony.
It was 91.
Yeah.
All
right. We'll go ahead and make that change. Thank you. That doesn't change the scoring though.
No,
Right.
But it just explains that.
it doesn't. Yeah, he's right.
I understand.
So on page 9, I can't remember if the court addressed this or not when the court went through it, but 10 of 25, I believe he should have been on bond at that time. I think we addressed that, but I don't.
I thought I did. Yeah.
That's
yeah.
one, first one you did.
On 20 of 25, which is page 13, it's indicating that he was on bond, but I don't believe he was. I don't see a entry that would correspond with him being on bond. And I confirm that with Mr. Saladez, he doesn't believe that entry is
Oh.
correct.
This case coming back. Our case here has been, all right. That makes sense. We'll go ahead and change that. Thank you.
Entry 23 of 25 on page 14. It shows an offense date of 3/5 of 24, but when I look at the Mecosta County circuit court records that are online, it should be July 21st of 23.
Mr. Burnfoot, can you tell us about that one? That is, we're looking at the case in Mecosta County, which is an allegation of unlawful driving away of a motor vehicle and flee and elude in the 4th degree. Hey, Mr. Wiggins, what were you looking at?
I went to the Mecosta County Circuit Court online records. It's actually MI court case search.
Okay. Yep.
It shows a case ID of 2024. So the circuit court number is 2024 10848 FH, currently pending on the 49th Circuit Court.
So,
Oh,
yep.
we have the 49th Circuit Court matter resolved with a did we- I'm not sure again whether we pled that or not, but that one is resolved. But these others as well, the most recent ones, I think the New York District Court.
You set their hearing on 4/22 according to the record.
Yeah.
There was.
Doesn't look like he hasn't pled yet. Doesn't look like he's pled yet because it sounds like.
I believe it was.
So the only question here is the offense date. I think the arrest date is probably correct because he probably didn't get arrested until 2024. And that would explain the case number. So the question is did the offense occur over a year ago? Right?
Yes, that's consistent, but July of 23-ish.
Is it July or January?
July 21st.
All right, we'll go ahead and make
When's the
that.
Wexford, when was the Wexford incident? Was that in just August?
August.
That makes sense.
Yep.
And then offense 24 of 25.
Mhm.
It's listed as offense date of 3/5. The court records show, again, from Mecosta County, show it was 3/4. And then the charges at arrest are just flee and elude fourth, not the UDAA that's listed.
He got everything dismissed, but he pled to driving on a suspended license, fines and costs.
No, but was there a UDAA charge? What happens here is entry 23 and 24 of 25 include the same charges. However, and that just may have been a duplicate by accident. What Mr. Wiggins is suggesting is that in 24 of 25, the only actual charge was flee and elude. In other words, there wasn't an allegation that he stole a vehicle.
The UVA.
Yeah, so we'll go ahead and remove that UDA and we'll make the offense date the March 4th.
I can see that.
Anything else, Mr. Wiggins?
Your Honor, on CFJ 284, page 16, under the family section, I know there's not a child listed, but I do know in the body of the report, it did reference a child, so I didn't know if we needed to make a change there.
Are there any children, Mr. Burns, that need to be listed in the family section?
He has a 17-year-old son.
All right, and the name of that son?
Jeffrey Maxon, third.
All right, so we'll go ahead and we'll add an entry for a son, Jeffrey Maxon III, and he is how old?
8606.
I'm sorry, again, so 17?
17, yes.
Thank you very much.
Sorry, Your Honor, I
That's
was
okay.
saying his birthday, 8606.
All right, thank you. And what city does he reside in?
Costa,
And
Big Rapids.
thank you. All right, anything else, Mr. Wiggins?
Because probation was not recommended, there wasn't a term of restitution, but there is a restitution of $1,516 to the recent schools. Is it consolidated schools?
What was that amount?
1,516.
Okay. All right.
We don't dispute that.
All right, anything else, Mr. Wiggins?
I believe that's it.
All right, Mr. Burns, any corrections, objections to the content of the PSI?
No, I have no additional ones, and I appreciate the corrections and revisions that the two of you have both pointed out.
All right, thank you. All right, Mr. Burns, then I will turn to allocution. Yes, sir.
We've spent time talking on this, and I know everybody has spent a lot of time reviewing it, and I've talked to both Corey and your probation, and I understand where this one is. So I'd like to point out that it is a straddle cell. I do have the other counties worked out where we'd be able to be in Mecosta. Not that it factors in. Mr. Maxon is in heart failure. He's got his vest on now with his monitor. Be much more appropriately addressed in Mecosta. As far as the offenses themselves, I would just like to point out they're not born out of malice, or they're although they may have been malum and say they weren't born out of malice, malicious intent. They really were born out of fear. The result was terrible, and he takes responsibility for that. Just ask that we, I also, as I pointed out, I feel that the sentencing guidelines are draconian and indefensible on many levels. I think that with the gap here, it's much more clearly, he would be arguably able to be kept in county. I think without the gap that, as you know, we've all meticulously gone over, and it does not appear that there was a gap. Unfortunately, he caught a serious thing when he was hanging around the wrong people when he was a very young man, and got himself a record early on and has not been able to shake that. So now it's going to have some sting again. But I would just ask again if there's a way to keep him in county. But other than that, I appreciate everybody's time on this, and I know that the county has expended a lot of time and effort on this. So thank you.
Thank you. One moment. Mr. Wiggins.
Thank you, Your Honor. There's several things that stand out about this case for me. One, when I reviewed the defendant's criminal history, I show that about 16 out of the 25 offenses listed, he was on some sort of supervision, whether it be parole, bond, district court probation. That's about 64% of his crimes came while he was supervised. So it's clear that, and the department believes this as well, he is not supervisable. He committed the crimes while he was on bond for Gratiot County. Then he absconded on their bond, picked up an absconding charge during the pendency of our case. Then after our case, he picks up another flee and elude. And then going through his history, he's escaped from jail while waiting trial. He clearly has a history of fleeing from police officers and resisting arrest. In our case, he fled the Wexford County Sheriff's deputies in the Mesick area by extinguishing his lights, speeds of excess of over 100 miles an hour and over 70 miles an hour in the trailer park up there, driving through yards, hard braking and turning around and going the other way, passing cars on double yellows, running stop signs, crashing through a chain link fence to school, and fleeing on foot. I'll be honest, as I'm reading this PSI and the report over the weekend, I'm envisioning it's like the Dukes of Hazzard and Smoking the Bandit, for those of us who are old enough to remember that. He put law enforcement at risk and others that were at risk on the road. The only saving grace in this case is it was after midnight when this all happened, so there weren't a whole lot of people on the road. Clearly has no regard for anybody other than himself. And he even admits the reasons he committed the offense was because he didn't want to go to jail. He just shows a complete lack of respect for law enforcement and human life, honestly. The Department of Corrections is recommending 16 to 24 and 13 to 30 in these cases. The guidelines are 7 to 23. Clearly established reasonable grounds that he can't be supervised. And I'm going to ask the court to adopt him or sentence him to the top of the guidelines. Thank you, Your Honor.
Thank you. All right, Mr. Maxson, before the court issues a sentence, you have the right to make a statement if you choose to do so. I now turn to you, sir.
Yes, Your Honor, I'm sorry for what I did. When I was in graduate jail, I told the officer I needed my meds, heart medication. And I didn't get up. And the time that I got out was Friday, like 4:45. I didn't, I called the tow truck company and I needed my heart meds and I didn't get them. And the following day I went to Carson City, heart complications, about died. I lost an uncle, in jail for heart complications. I mean, it's a stupid excuse why I didn't want to stop. And I put everybody's life at risk. It was a stupid mistake. I wish I'd never done it. I putting everybody in danger and my dumb choices.
Thank you, sir. Yes.
I'd like to make one comment. I just have to point out that's highly irresponsible, but I cannot imagine what they suspected him of. To chase someone through the town at those rates of speed and through these rural areas is also very, very upsetting. And there should be corrective action taken on the department that would subject the community to that kind of risk unless, again, they're in hot pursuit of somebody who's a offender, so it's just, I just have to point that out. This doesn't happen with those egregious facts. If you don't have somebody right behind him going those same speeds, pushing someone who's clearly running. You got his plates, you got his stuff. That's something, anyway, that's a decision that should be made a different way. I just had to bring that up. Not that it affects necessarily Mr. Maxon's sentence, but.
All right, thank you. All right, one moment as I put together some thoughts. All right. So when it comes to sentencing, as I've mentioned in the past, when I used to be a military judge, we would just issue a sentence and stand up and walk away. They wouldn't say anything. They law strongly discourage you from even explaining it. However, in Michigan, we don't do that. We're required to discuss a lot. Specifically after the decisions of People versus Posey, versus Steinhaus, Steinhouse. I might have gotten that name wrong, but anyways, we've got to do a lot of talking to explain it, justify the sentence. And so there are a lot of things here to talk about in the case. Number one, why did law enforcement pursue him? The suggestion is that they already had his plate. However, I went straight to the description of the offense, and the reason they pursued him was plates were wrong. So I take a straw, and I'll disagree. I strongly disagree. There doesn't need to be any reprimand for the law enforcement officers. They didn't do anything wrong. I strongly disagree. When somebody is, lights come on, you stop the car. That's what the law says. The law doesn't say drive as fast as you can get away and then the police officers have to stop. When the lights come on, you stop the car. That's it. I don't find that draconian. It's very, very simple. This concept that is sweeping the country, that you can disobey the police officers whenever you choose and then turn around and try to blame them, I disagree with. The lights come on, you stop the car. That's what the law says. If you don't do it, you're the one in the wrong. Now, we've already covered here that the defendant was fleeing police at over 100 miles per hour. They couldn't just go and walk away and let the guy go because they didn't know who he was, because he didn't have the right tabs and plates and so forth on the vehicle. That doesn't make any sense. So then I turned, I'll accept, we've already heard a lot of discussion about the events of that night. My Mr. Maxon's choice. Take a look at what he said. He said he was sorry for what he did. I don't buy that. He's sorry he got caught. Lights off, intentional. 100 miles an hour, intentional. Neighborhoods, intentional choices by Mr. Maxon. Now, in his description of the offense, he said, I stupidly panicked and took off like an idiot. Yes, I could characterize that statement or your actions as stupid, maybe, but I don't want to be offensive, so I take it as this. It was intentional. You intentionally fled police knowing you had other warrants, and you put people at risk. It wasn't stupid. It was extremely reckless and obnoxious. You violated the law, you put other people at risk, and the law enforcement officers were doing their job. Then when I look at your criminal history, there is so much here for proportionality, reasonableness, and reasonable grounds. You are not supervisable. You have had in conviction 2 of 25, or 20 of 25, you tested positive while on parole, quote, numerous times, end quote. Conviction 3 of 25, you were on bond, again, underneath the narrative, testing positive numerous times for controlled substance. 4 of 25, you were on bond, and this is when you picked up the escape. And then there are other entries underneath the narrative for that offense regarding the testing positive for multiple times and so forth. Then number 5 of 25, you were on parole. Now, I don't know what the resolution of that case was, but I can look down to the very next one and see that number 6 of 25, you were on parole. Number 7 of 25, you were on bond or parole at least when that offense occurred. And that one's a driver license suspended. All right, not a big deal, but here's what I circled also. No plates. Does that sound familiar compared to this case? It sure does to me. But driver license suspended means the defendant is always going to choose, or not always, but will often choose to disregard authority. Number 8 of 25. Again, the defendant was on bond and he picked up probation. Looks like a probation violation. Some additional jail. Then he picked up 9 of 25. Then he picked up 10 of 25 while he apparently was on bond. Then we've got more driver license suspended. Again, the person will disobey authority when he thinks he can get away with it. Oh, and by the way, count and entry 10 of 25. The defendant picked up an R&O, which of course is what this case is all about. We get some other disorderly persons, some more driver license suspendeds come along. Then we got entry 13 of 25. The defendant was on probation when that happened. Then when we look at 14 of 25, that one's just a motor vehicle charge. There's not a whole lot there, but when I look at 15 of 25, that occurred while on bond. Then we have 16 of 25 while on bond, driver license suspended. Again, will do what he wants when he thinks no one's looking, as long as he doesn't get caught. Then we have 17 of 25. That occurred while the defendant was on bond. And we have, can't mention 18 of 25 too much because that one was dismissed. Look at 19 of 25. That occurred while the defendant was on bond. Then we have 20 of 25. This is one of the charges that's pending. That occurred while he was on bond. In fact, he was on bond for that when this case occurred. 1 of 25, if I didn't cover that one. Yeah, 21 of 25 while on bond. That one, I'm sorry, that was the one that resulted in a conviction. And is the one that we're here for today. Again, Arno, fleeing, looting. And meanwhile, he had this other case from Gratiot County, which he was on bond, which allegedly occurred while he was on bond. He's got 23 of 25, another one while on bond, 24 of 25, 25 of 25. No, all of that establishes that the defendant is unsupervisable. All of that establishes the defendant will disregard law enforcement or any authority when he gets the chance. There is no better, or hardly ever in a case where I look and say, this is the case of proportionality, reasonableness, and reasonable grounds. Now, and everyone is allowed to have their opinion. And I do appreciate that Mr. Burns went above and beyond the duty that I would see from almost any defense attorney, and scheduled a meeting last week and met with myself and Mr. Wiggins in chambers. We talked a little bit about some theories, and I didn't say a whole lot because it's never really appropriate. At least I don't think so. But I don't think our laws are draconian for putting people in prison. We have slashed the rules and laws, which is absolutely okay. I don't take any challenge with it. That makes it very difficult for judges to put someone into a prison cell and even into a jail cell. When I look at conviction number 2 here for the attempted flee and elude, it is a straddle cell, which the law says I'm not allowed to give jail unless I find there to be reasonable grounds. So we've done a lot in the state of Michigan to help people avoid confinement. However, we still give the judges authority, and I've already established enough reasonable grounds. And I, again, don't believe our rules are draconian. The law is pretty simple. When the lights turn on, you stop your car. That's simple. I don't, and when you have had these issues in the past, and you have bond, I'm sorry, you're on bond pending other cases in other places, you know what's going on. And when you've been to prison 3 times in the past, you know what's going on. This wasn't an act of stupidity. This was an intentional act putting people at risk. Now, and I understand that the defendant has some medical issues, and I do appreciate that. And I am quite confident the system will help take care of him. However, if his medical conditions, and I'm not challenging him, he didn't have a heart attack driving at 100 miles an hour, careening through fences and other things. Leading police, getting out of the car and leading police officers on a chase. And I'm not the type who's going to allow a medical condition to go, well, you know what, based upon your age or a medical condition, I'm not going to give you jail. That's not how it works. I believe that the judges are supposed to place a sentence, kind of like placing a price tag on someone's choices. If the Department of Corrections chooses to let them out some other time, great. If they are able to provide a medical treatment, great. That costs the state of Michigan something to pay for, that's on the state of Michigan. That's not my job. My job is to sentence the defendant based upon the conduct that I see and based upon the report. And I've covered a great deal. The court sentences a defendant to $268 state minimum fees, a $130 crime victims' right fund fee. I'm going to respect that the law changes in a couple weeks, so therefore I'm not going to charge any court costs. And I'm not going to charge any fines, and there's no attorney fee as Mr. Burns has retained.
Your Honor?
Yep.
I just had one, when you were
Sure.
just saying your factual statements, you said that he'd been to prison 3 times, he's been twice. I just want to make sure you had
I'm
that.
sorry, thank you.
No problem. I just wanted, that was right.
It's okay. Here's what it,
There's 29-year gap, but it was 2 years.
Yeah, thank
two times.
it was on CFJ 284. Maybe we need to make that change. On page 1, in the 4th paragraph, it says he has been to prison for 3 prior sentences, and I misstated it. Thank you. I accept that.
I just want to make sure that
No.
you in your head had.
Yep.
Yeah.
I appreciate that. Thank you very much. The court has, sets restitution at $1,516 payable to Mesa Consolidated Schools. The court sentences the defendant for count 1. One moment. Court sentences the defendants for counts 1 and 2 to a prison term of 16 to 24 months for count 1 and 16 to 30 months for count 2, and awards the defendant in each matter 63 days of credit. Again, I find that this sentence, based upon the information I've already stated on the record and that which is contained in the pre-sentence investigation report, establishes proportionality, reasonableness, and reasonable grounds. Have I missed anything, Mr. Saladay?
No, Your Honor, thank you.
All right. Mr. Maxon, Mr. Burns is going to bring you 2 copies of 1 document. You're going to place your initials on the first copy. Place your initials on the first copy neither elects nor waives any rights. It merely acknowledges receipt of the other copy. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the pleas in this case, any appeal must be done by filling out or filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document.
Your Honor, I'm handing you the document right now.
All right, thank you very much, Mr. Burns. All right.
Is that appropriate?
Yeah, you're,
I just want to make sure.
no, you're good. Thank you very much. Oh, wait, hold on. I'm just going to add underneath request for appointment of counsel. He didn't date it. I'm just going to date that line so that way his days are marked according to the
Thank you.
appellate record. Thank you. So I'm just adding to it April 15th, 2024. I'll file that and the clerk's office will get that ball rolling. Anything else, Mr. Saladay? Mr. Wiggins?
No,
And Mr. Burns, anything else?
Nothing else. Thank you.
Thank you, gentlemen. We are adjourned.